Good afternoon, everyone. We are going to start the presentation. And so this will be the last webinar of the webinar series that we conducted celebrating the October month, the Cybersecurity Awareness Month. And from the beginning, we had several discussions, several presentations touching different topics, which is important for our day-to-day lives, cybersecurity awareness, like social engineering, cybersecurity standards, fake news detection, machine learning and AI approaches in cybersecurity, and so on. So today we are going to talk about another important aspects of cybersecurity, especially for awareness for our day-to-day lives. And let me introduce today's speaker and her title for today's talk. And she is someone very familiar to us, Dr. Argyri Panezi, and she will be talking about the proposed Bill C-26, a framework to protect Canadian critical infrastructures, which is on the law side or legal side of cybersecurity, and I'm sure it will be interesting for most of us. Let me introduce the speaker reading her bio. Dr. Panezi joined UNB Faculty of Law in 2023 after being awarded the Canada Research Chair in Digital Information Law and Policy in Tier 2. She holds a law degree from University of Athens, an LLM from Harvard Law School, and a PhD from the European University Institute. Dr. Pandezi's research explores the effects that disruptive technologies have on citizens, institutions, and law. She has been writing about legal challenges associated with the digital transformation of cultural heritage institutions, the digital transformation of justice institutions, law and AI, and about privacy challenges in Web3 era. So over to you, Dr. Panezi, for today's talk.
Thank you. Thank you very much to you, Wendy, for the invitation. Thanks to everyone at the Cybersecurity of the Canadian Institute for Cybersecurity, who has been extremely welcoming, also sharing your expertise. Very recently, we were together at the Industry Summit, which was a great opportunity for me to also think harder about the issues that I'm going to be talking about here today, which is this legislative effort from the Canadian government to implement a framework for cybersecurity protection. Now, let me share my slides and start right away. As introduced, I will be talking about the proposed Bill C-26. This is a framework to protect Canadian digital infrastructures. The bill is an act, this is the title of the bill, an act respecting cybersecurity, amending the Telecommunications Act, and making consequential amendments to other acts. So as the bill is still a draft bill, has not passed, let's look at the status first and then explain a little bit what this bill includes. As you saw from the title, it amends an existing act and it introduces a new piece of legislation. So it's this sometimes is hard for non-lawyers to navigate so that they understand how the legislative process sort of moves forward. So at the moment, the bill is still with the House of Commons, tabled with the House of Commons in its being reviewed by a committee, consideration by committee, towards its third reading. The bill needs to pass all three readings to move forward. The first reading was completed, as we see on the slide, in June 2022. Second reading, March 2023, and we're here. Now, the bill, as I mentioned in the previous slide, is before the House of is a House government bill, and the sponsor is the Minister of Public Safety. Now, these two parts that complicate the bill a little bit are fairly straightforward once you read it. I simplify here, but the bill seeks to first amend the existing Telecommunications Act, also introducing certain reforms to the Canada Evidence Act, and then introduce a new piece of legislation, a new act, which is the Critical Cyber Systems Protection Act. This is new. Canada has not had a Critical Cyber Systems Protection Act before, has not had a framework to protect critical systems before. This is the purpose of the bill, citing the wording of the bill itself. So the government wants to help protect critical cyber systems, support continuity and security of vital services and vital systems, and ensure that cybersecurity risks in respect to critical cyber systems are identified and managed. Here we already see that the bill is focused on risks associated with the supply chain and the use of third-party products and services. This is loud and clear throughout the whole bill. And within this aim, the bill wants to ensure protection of these systems and requires that the cybersecurity incidents are detected, reported, so that the impacts that these incidents might have are minimized. So in a nutshell, risk identification, risk management, detection of incidents, minimization of impact in order to reach the broader goal of protection. Now, what are critical sectors or critical systems or critical infrastructure? This language is, these are different terms that we use referring to pretty much the same notion. When you look at equivalent pieces of legislation around the globe, you can see that critical systems are understood usually negatively. We know them when they are threatened or when a risk comes to play. We also understand their criticality and feel their criticality when something goes wrong. So the bill, including these two parts, first reforms the Telecommunications Act and adds telecommunications to a concrete list of critical infrastructure or critical sectors. That's the first important thing. And then it provides a list of what are federal regulated private sectors and are now also considered critical cyber systems. Which are these critical cyber systems that fall under the scope of the bill? As we said, telecommunication services and interprovincial or international pipeline and power line systems, nuclear energy systems, transportation systems that are within the legislative authority of the parliament, banking, and clearing and settlement systems. And to understand how these different sectors and these different systems are regulated so far, let me show the regulators. So the Minister of Industry is responsible for telecommunications, the Minister of Transport for the interprovincial and international pipeline and power line systems, the Canadian Nuclear Safety Commission for the nuclear energy systems, the Minister of Transport for transportation systems within the legislative authority of the Parliament. You can group that together with two. And then the Minister of Finance, along with the Office of the Superintendent of Financial Institutions, responsible for banking systems, and the Bank of Canada, responsible for clearing and settlement systems. Now, the bill introduces this list. However, it gives the Governor and Council the power to amend the list, add or delete any service that is listed under this provision, Schedule 1 of the bill, which includes the list that I read earlier. The Critical Cyber Systems Protection Act, the second act, which will be applicable also to telecommunications, since the first part of the bill explicitly says that telecommunications will be considered critical systems. in a nutshell, introduces the following provisions and obligations for designated operators of critical cyber systems. So it says that designated operators must establish and implement cybersecurity programs, and these are sections 9 and 14, rather elaborate provisions asking designated operators to give notice of their cybersecurity programs, implement and maintain them, also to have designated experts that would be communicating directly and reporting with regard to the programs. The Act asks also designated operators to identify and mitigate supply chain and third-party risks, and these are sections 15 and 16. And as I said earlier, this seems to be a primary goal of this particular legislative effort to mitigate third-party risks and supply chain risks. Designated operators must also report cybersecurity incidents. This is an important clause and an important new provision that will promote transparency when it comes to cybersecurity incidents. Along with the reporting of cybersecurity incidents comes the triggering of a whole mechanism whereby government actors are giving cybersecurity directions to these critical systems operators. And these are sections 17 to 22. Importantly, the bill also facilitates information exchange between the relevant parties in order to deal with threats and actual incidents. And finally, it authorizes the enforcement of the obligations under the Act and imposes consequences for non-compliance. Now, the operators must keep also records respecting their compliance under Section 30. What are the challenges that this bill brings about? And that's, there's still time for amendments, and the reason I think that the bill moves forwards rather slowly now before the House of Commons is that there concerns have been voiced with regard to a number of issues when you look at the letter of the bill more closely. Over the next few slides, I'm going to present the wording of the legislation to show that there are issues with regard to affording broad powers to government actors. There are issues with regard to secrecy, non-disclosure obligations when it comes to the compliance with orders. There are issues with regard to the way in which the bill deals with government liability for any for harms, and also with the ways in which the bill introduces judicial review. And finally, I want to voice my own concern about implementation costs, which is more of a challenge, a necessary evil, but I think that is worth also talking about and adding to the table. Now, the broad powers, why do I think that this is an issue that the bill needs that we need to pay attention to when it comes to that bill? Operators must comply with any, this is the wording of Article 20 of the bill. Operators must comply with any measure set out in the direction of the purpose, in the direction for the purpose of protecting a critical cyber system. The minister may, by order, direct a telecommunication service. This is part of the first part of the bill that focuses only on one of those critical systems. A telecommunication service provider to do anything or refrain from doing anything. That's 15.2.2. And I have the provisions here for you. You can see how there are no, there are some requirements and there are some exceptions, but the wording is rather broad. The main rule is rather broad: comply with any measure in the direction under 21, the second line that you read here. The same for the minister's order to the Canadian telecommunication system provider. It can go as far as ordering the provider to do anything or refrain from doing anything. And here you see that in case of necessity, the telecommunication service provider might be asked to prohibit from providing any service to any specified person, including a telecommunication service provider, and direct the telecommunication service provider to suspend providing for a specified period any service to any specified person, including a telecommunication service provider. So the language is broad. This is to a certain extent to be expected when a bill wants to not really name specific occasions, but introduce a rule that is flexible, that can apply to different circumstances, that is also future-proof. We might be aware of the kind of risks that we're facing today, but we cannot anticipate all types of risks that are coming into the future, and legislation is difficult, is slow. The legislator here feels the need to be quite vague and more capture more scenario than less. That's one side. The flip side is that you have very broad powers here, right? With regard to the second challenge or concern, secrecy. So there are prohibitions against disclosures put in the bill. And again, let me caveat by saying this is not for, this is for a good reason, right? Where the legislators had in mind cases where secrecy is important to safeguard national security. Now, again, the wording is quite broad. If necessary, telecommunication systems operators must comply with secret orders. That's under 15.1 and 15.3 of the bill, 15.1.2 and 15.1.2.3 of the bill. If necessary, all designated critical systems operators must comply with secret orders as well. The second part, 24 and 25 of the bill. And here are the sections that I mentioned. The wording is similar in both parts. Just to sample the wording from the Telecommunications Act part, the order may also include a provision prohibiting the disclosure of its existence or some or all of its contents by any person. And the same for cybersecurity directions to any designated operator under 24. As you see in 25.1, a designator might be allowed to disclose the fact that the direction was issued and its content, but only to the extent that this is necessary to comply with the direction. Otherwise, the rule might be secrecy. The third point of concern or challenge with regard to this piece of legislation as we read it now is that it imposes, zero or minimal liability to government actors who also enjoy certain immunity, and that's also understandable to a certain extent. But the standard is rather low, so all they need to do is act in good faith. Now, during judicial review proceedings, judges might hear submissions of evidence and listen to and review orders in the absence of the public and in the absence of the applicant and their counsel, if the judge deems that this is important, if they think that disclosure of information might harm international relations, national defense, national security, or endanger the safety of any person. So here again, the part that I've highlighted in red kind of gives us a justification for this rather powerful rule. However, besides necessity principles that are being obviously taken into account here, we don't really see proportionality or due process measures to counterbalance this very, very broad and powerful power that a very broad and strong power that is given to the government as with regard to issuing orders in secret and potentially also reviewed judicially in secret. This is the liability clause or the non-liability clause, and this is the judicial review clause. Now, the final point of concern, in my view, is also implementation costs. And this is not only for the industry, and there I'm mostly worried about small and medium-sized enterprises, and also about guidance with regard to what level of detail needs to be included, etc. I think it's a move to the right direction, that we ask for reporting and transparency, that the bill asks for plans, cybersecurity plans to be shared with the government. But then we must also consider or at least be aware of the fact that the new framework will introduce will come with implementation costs also for the government, and be cautious and cognizant of the fact that the government needs to have the human power, human capital, and expertise in order to process all of this information that will come their way. There are also very strong concerns expressed by civil society and scholars. Notably here, there's a joint letter signed by the Canadian Civil Liberties Association, the Canadian Constitution Foundation, and other civil society groups that you see on the slides. And this is not an exhaustive list of their concerns, but mostly they're noting that the bill as it is drafted now opens the door for surveillance obligations, and doesn't really have safeguards in place for state surveillance, therefore undermines privacy. No real guardrails to constrain the potential of abuse of this power that the bill provides, and they're very worried about secrecy, which these actors argue that it undermines accountability in due process. They're quite worried that the bill has no sufficient justification for how broad and powerful it is from the side of the government. And this is these are some points to conclude and give some time to discuss and maybe answer some of your questions. I think that the introduction of this bill is an important step. Canada comes late, not that late, but Canada does not have a critical systems framework, critical systems protection framework, or a critical infrastructure or cybersecurity framework in its legislative toolkit, and it definitely needs that. We have their counterparts already either introducing or implementing very strong such frameworks. NIS 2, the Network Information Security Directive in the European Union, is has already passed and will be enforced from October 2024 onwards. This is an amendment of a previous such framework, NIS 1. Similarly, the United States has the NIST framework. I think that Canada, the Canadian legislator does very well to make this proposal a priority, make legislation a priority. However, good laws and well-construed laws do promote trust, so we definitely need to focus on making this draft much more robust, not only when it comes to the powers that it gives to the government, but also safeguards around these broad powers. so that we address the concerns that have been voiced loud and clear by civil society actors and scholars. Now, I also think that since we are, this talk is hosted by the Cybersecurity Institute, and I'm talking to experts, I think that the importance to invest in a culture of collaboration between the government and cybersecurity experts and industry is critical to keep, paramount in order to keep Canadian critical systems secure and Canadian data safe. Therefore, industry standards and practices need to go hand in hand with good laws and policies. And another point or final concluding point is that as we see, the government has legitimate reasons to fear dependencies, especially from third parties. Therefore, a good strategy alongside good legislation is to invest in Canadian infrastructure so that these dependencies are reduced. And with that, I will thank you and come back to our discussion with Wendy.
Thank you very much, Dr. Argyri, for that informative presentation. And I'm sure it must have been very interesting for all the attendees, especially focusing on the legal aspect of cybersecurity. If you have any questions, please feel free to put in the chat box. Yeah, we have one question there. Does the bill address actions that parties are required to address on any incident?
Yeah, if I understand the question correctly, so the bill introduce a framework whereby parties might be compelled to act in a certain way. For example, cut a person or a telecommunication service from the network, etc. And gives examples. There is a non-exhaustive list of actions that, for example, telecoms providers might be asked to take. Does it address actions? You mean, is the question directed towards measures that the providers have already been taking before the government steps in? Yes, and not in detail, if I'm understanding the question correctly.
Yeah, thank you. So we have the second question. How will SMEs incur additional cost as a result of the bill besides the cost of compliance?
How is a good question. They need to comply. If this passes, they would need to comply, and I'm not sure that I would. So, well, they would need to comply, and they would also need to hire or designate a person or a team that reports to the government. So minimally, this the compliance cost involves human capital. And otherwise, with regard to complying with orders, I think that when a cybersecurity incident comes to forth, that the compliance costs there, besides the fact that you have costs associated to the compromise of your system itself, I'm not sure that these costs are worrisome. These additional costs are worrisome because, in theory, the government and the provider work towards the same goal when an incident arises, which is to mitigate the effects and to restore the integrity of the system.
Yeah, thank you. So to add on to that, according to your view, according to like what you have seen, do these SMEs are aware of this bill and like its importance or like its effect? I can understand the big companies might be aware, but what about the SMEs?
Right. I think that especially telecom providers might. I could imagine smaller telecom providers not necessarily not being aware of the bill, but not being able to meaningfully engage with the text or voice their concerns if they have any, and that's one. Two, I haven't seen any discussion voicing concerns regionally. For example, what are the what would be which actors would be impacted when we're looking at Atlantic Canada, right? What are the specific dependencies or the capacity of providers of these critical systems in specific areas? I would be interested to look into that more, especially as we're seeing the list and which are these providers in our province or neighboring provinces.
Yeah, thank
that
you.
have also been facing,
Go on.
that have also been facing, both human capital and financial constraints.
So we have a question in Q&A. Does the bill extend to international TSPs?
Well, the bill would allow government to compel Canadian operators of critical systems. Now, they might ask them to comply with an order that affects the relationship that these operators have with the international actors. Yes, clearly.
Yeah, thank you. So Rashid
including contractual relationship.
Yeah, thank you. So Rashid is asking, how does this bill intend to address challenges in light of the rapid pace of technological advancements? Good question.
Yeah, no, this is a very good question. The government is also trying to. There's a consultation. There's an ongoing consultation and efforts to think about regulating AI, and this is not in sync necessarily with this bill. So we might want to look at these efforts together. And as I mentioned within the presentation, there's very broad language. I think that the rationale of the legislator, with certain perhaps unintended consequences, was to draft a bill that is future-proof. Whether this was successful or not is for us to also assess, and I think that it was not that successful. So that would be my personal sort of view in trying to answer Rashid's question.
I think there is a follow-up for that. What happens when a lawsuit arises, but the bill doesn't adequately address the matter?
Yeah, so the bill has not passed yet, right? And we've seen that there are issues with judicial review. So the first question is constitutional challenges to the bill. If the bill passes in the way that it's drafted now, and with the kind of concerns that are voiced by a number of actors now, there's a very high chance that it's challenged at the constitutional level. Now, I can also see I can also see third parties taking legal action if they're affected by orders that are introduced in view of the bill. There's the national security exception that usually becomes also a factor that is considered before judicial review. So it really depends on what is at stake. But on abstract, I think that right now the letter of the bill really opens the door for such challenges, both at an institutional level and also from industry.
Thank you very much. So from the questions that we can see, a lot of people are interested on this topic. And thank you very much, Dr. Argyri, for coming today and giving this nice presentation, informative presentation. And this concludes our October Awareness webinar series, and I'm really glad to have you as our final presenter. It was really nice presentation, eye-opening presentation for all of us. So thanks for joining, and thanks for being an interactive audience. Have a nice day, and see you on another webinar for some time. Thank you very much.
Thank you very much.